Lordship, for inclusion in the list, underwriting application.
This is for?
Application.
Yes.
Well, may I be permitted to mention, this matter already fixed on 14th of this month by the earlier bench, But it's a hearing matter, let the matter be appear on the date fixed.
No. Hearing of a claim case.
Claim case, I am for the claimants respondents.
Okay.
It's ready for hearing,
So-
paper book has been filed. I have received the paper book.
Anyway, let it appear as to be mentioned. Thereafter, the date can be fixed.
Published.
I lead to an extension of interim order application in the second appeal.
Second appeal application for extension of interim order.
Interim order. Injunction. And another is, my lord, one claim case was filed, which will let it come for direction of the paper book, my lord.
No. Claim case ready for hearing.
Fine. It was filed, memo was filed, only paper book direction is required.
Okay, as to be mentioned.
Mention one of the matter is a limitation act for the application for section 5.
Section 5 in second appeal.
Yes, my lord.
Have you served notice upon the other side?
No, it's not second appeal, but the first appeal. But because the eviction has not yet been admitted.
No, first appeal.
Sorry, my lord, it's a second appeal, my lord.
No. Second appeal, section 5 application. Both sides are to be heard. Have you served notice upon the other opposite parties? So without that cannot be heard out. So it's better serve notice and then mention.
Yes, my lord.
Serve notice and a copy of the application.
Yes, my lord.
My lord, may I pass?
Yes, please.
Ready for hearing.
Ready for hearing claim case? Yes.
May I permitted to mention, to be mentioned, claim cases, my lord.
Claim case is ready for hearing matter.
No, my lord, it's first time we are actually filed the memorandum of appeal, but waiting for paper book direction.
Okay. Give the slip. Note service of notice is complete.
Service notice is complete.
The opposite parties have entered appearance.
I'm for the claimant, my lord.
Yes.
My lord, short case of claim case, my lord. All notice has been served, mentioned for a hearing.
So opposite party has
Yes,
entered
my lord.
appearance.
Both opposite appear.
Okay, to be mentioned thereafter.
Yes,
Date
there.
for hearing.
May I mention one matter for inclusion in the list? This is ready to be heard, Lordship. This is a claim case matter.
Okay.
My lord, may I be
May
permitted to
I-
mention 4 matters for inclusion in the list, claim case matters.
Yes, give the slip.
May I, Your Lordship, kind permission to mention a matter? It is a Section 5 Limitation Act hearing for inclusion in the list.
Section 5 in which application? Which case?
Second appeal.
Second appeal. Have you served notice and
Yes,
copy
Your-
of the upon the other
Yes,
side?
Your Honor, I have annexed it.
Yes.
My lord, motor accident claim cases ready for hearing, paper book served and filed.
Yes, to be mentioned.
We have, Your Lordship, liberty to mention an origin side matter, my lord. This was made part heard, my lord, by my lord.
Anyway, it will appear day after on Friday as to be mentioned.
Yes, my lord has fixed the date on the 6th of November, but due to change of determination.
Anyway, Friday it will appear.
Very well, my lord.
Grateful, my lord.
Lord, may I have your lordship kindly to mention one motor accident claim case hearing, the matter, the paper book has been filed and served on the other side as well, my lord. Ready for
Okay,
hearing.
to be mentioned.
Yes.
বলে দিয়েছি।
Number 1.
My lord, I am for the respondent. Matter fixed for Monday. Mr. Pahari is not available. He was sick.
So respondent who is appeared? You are for the respondent.
Yes.
Who is appearing for the appellant?
Mr. Pahari is not available.
Uh,
He was sick.
So have you filed your paper books?
Yes.
Your paper books have been filed?
Yes.
Yes, record and order.
Hearing for fixed next Monday.
Learned advocate for the opposite respondents is present. It is submitted by the learned advocate for the respondent that the paper books have already been filed. Let this matter appear for hearing on
Monday.
17/11/2025. Let the other side be intimated by notice. Under the heading hearing.
I appear for the respondent claimants, my lord. on a paperwork file. My lord, I have served also to my lord. Matter is ready for hearing, my lord.
Yes, record and order.
What date, my lord?
Learned advocates for the parties are present. It is submitted by the learned advocates that the paper books have been filed and the matter is ready for hearing. Let this matter appear for hearing on 18/11/2025. 18.
All right.
Chaplain, my lord.
My lord, I am appealing for the respondent claimant number 1, my lord.
My lord,
Respondent claim.
there are two applications. One is, my lord, application for condonation of delay, and two is, my lord, stay application, my lord.
Yes, let me see.
This is the copy of challan, the statutory amount, my lord. As per my calculation, my lord, there is a delay of 307 days. 307 days delay in filing the
When was the award passed?
award passed on, my lord, 19th May 2023.
Yes, let this application be allowed, condonation.
Yes, my lord.
Yes, record and order. Learned advocates for the parties are present. The application for condonation of delay being Can 1 of 2024 is taken up for consideration. Heard learned advocates, peruse the petition filed. Upon perusing the petition, this court is of the view that as the appellant has shown sufficient grounds for condonation of delay, the delay should be condoned. Stop. Thus, delay in filing this appeal is condoned, and Can 1 of 2024 stands allowed and disposed. Stop. Can 2 of 2024 is also taken up for consideration. In the instant case, as the appellant insurance company has deposited the statutory amount of rupees 25,000, the judgment and award passed by the learned additional district judge first track first court Krishnanagar, Nodia in MSC case number 192 of 2018 shall remain stayed for a period of 5 weeks. The appellant during this period shall take steps to deposit the sum awarded along with interest excluding the statutory deposit. Okay. After making the deposit of the awarded sum, parties are at liberty to mention the matter mention the matter.
My lord, another thing, my lord, kindly direct the learned Registrar General to invest that amount.
That is the usual procedure.
No.
The amount deposited, yes, record, the amount deposited shall be invested by the Registrar General in the usual course, in any nationalized bank.
My lord, since my learned friend is appearing, my lord, kindly pass direction for preparation of paper book.
Paper book, my lord.
Okay. Let the paper books be filed within how soon can you file?
4 weeks, my lord.
4 weeks? Let this matter appear on 9/12/2025.
My lord, in 9/12, my lord, 5 weeks will not expire, my lord.
No, paper books.
Paper-
That interim order will continue. These paper books will be filed within that period. You comply it within 5 weeks.
Very well. Grateful to your lordship.
Or you want some more time? No, let him file the paper books. Thereafter, the date will be fixed for hearing.
Yes, yes.
Acha, let this matter appear on 9/12/2025 as to be mentioned.
সময় নিয়ে নিলে না, খরচটা করে নিতে হবে।
Number 4.
My lord, I am appearing on behalf of the appellant insurance company, my lord. Mr. Roy is appearing on behalf of the claimant. I have
Ma'am.
received the paper books.
For
Right.
hearing, and lordship, already I have filed the paper book that I have served upon the appellant. That is lordship's file. And lordship, I have filed one cross objection that is not appearing in the lordship's list. So lordship kindly tag with the court and fix the any date that that I have served upon the appellant.
My lord. Any day next week, my lord.
Learned advocates for the parties are present. As the paper books have been filed, let this matter appear for hearing on 19/11/2025. Let this appeal appear for hearing along with court
100 of 2025.
100 of 2025.
Grateful, my lord.
I'm blessed.
Fine, my lord. এই, কিসের? শ্রাবণী আছে না? শ্রাবণী ভট্টাচার্য? দেখিস। My lord, I'm for the appellant, my lord, the appellant for the, my lord, respondent claimant, my lord. My lord, all applications have been, my lord, disposed of, my lord, paper book also filed. My lord is ready for hearing, my lord, kindly fix the date for hearing.
Yes, record and order.
Paper book to
Learned advocates for the parties are present. As the paper books have already been filed and the matter is ready for hearing, let this matter appear for hearing on 19/11/2000.
Kindly
So earlier matter you are appearing?
Yes, my lord, December, my lord.
No, that is why.
December.
Earlier matter.
I'm not having, but
Okay, let this matter appear for hearing on end of this month,
End of
Very
this.
good.
Very good.
On 20.
25/11/2025.
Good, very good.
Number 6 and 7.
6, I am for the appellant insurance company, lordship. Already paper book I have received. I have also served upon Mr. Roy and Mr. Singh also. And kindly,
You didn't serve. I have paper, I have served.
no, affidavit of service. I have already. And paper book is prepared by me. Kindly fix a date for hearing, lordship.
Yes, record and order.
Lordship, it will be better if 1st December can be done. Before that, several matters are fixed.
Learned advocates for the parties are present.
Amendment.
As the
Can-
paper books are
Can one-
have already been filed, let this appeal
আর একটা কিসের একটা?
and cross objection
Yes, lordship, already in the list.
appear for hearing on after 2 weeks.
Yes,
Lordship,
lordship. First-
actually, this the appeal, the point of appeal already been decided, judgment has been delivered. The arising out of the same accident, 2 appeals filed. One filed by another lawyer and this appeal filed by Mrs. Shatra. So, lordship, the already judgment delivered. So only.
That regard, I have to take instruction. I don't have. আমার কাছে নেই। আমি তো জানি না, আমার কোম্পানি বলেনি আর কি।
Bring so
Lordship,
in
seven-
this regard,
হ্যাঁ।
Yes.
bring with the list of dates, compilation of the judgment.
Lordship, judgment already on that.
No, if it is delivered, you bring a compilation, serve a copy upon your learned friend.
So compilation, the judgment, this is with me. The judgment passed by Justice Bandyopadhyay, passed the judgment.
Very well.
Judgment with me.
You prepare a compilation in the meantime.
Lordship, I have got several matters. So take it
Very
on
well,
first.
Lordship, kindly
I'm
fix the
keeping it
pending.
on, I'm
Ah.
keeping it on 25.
Lordship, 1st of December will be
No,
better.
Lordship, not December.
1st of December. Next 2 weeks, several matters
Okay,
are
let
fixed
this
for
matter
hearing.
appear on
আমার সাথেই তো
1/12/2025, 2/12/2025 for hearing.
আপনার সঙ্গেই তো আছে। আচ্ছা দাদা কোনটা কোনটা
Yes.
কোম্পানিকে জিজ্ঞেস করেছেন আমরা বলতে পারি না আমাকে একটু করতে হ্যাঁ
কি ডিস্টার্ব করছো ওখানে দাঁড়িয়ে দাঁড়িয়ে তুমি? তোমার তো বলা দরকার প্রশ্ন নেই, তুমি আমার লাইনে কেন বুঝতে চাইছো? আমার লাইনে ধরো।
মেইন আউট আমাকে কোনটা কোনটা
So I am for the appellant. Here, Lordship, the paper book that have been served, I don't know whether Mr. Singh having the brief or not. Go. কি আছে এটা? সব দেওয়া আছে। Lordship, the earlier coordinate bench also Lordship fixed the matter for forwarders. So only paper book already paper, kindly the issue is very short issue involving the
Is
appeal.
it a part-heard matter?
No, not part-heard matter, Lordship.
No, then how how the matter appeared for orders?
After the hearing, the Lordship fixed for orders, but matter not touched.
No, question is,
Not
was
part-heard
the matter heard
No,
by the
no,
earlier
no,
bench?
no.
If you have already argued the matter before the previous bench, it is better to get it heard there.
No, not part-heard matter.
Okay, record an order. Learned advocates for the parties are present. As the paper books have already been filed,
And
let this matter appear for hearing. Yes, Mr. Singh, yes, when shall I fix it?
After 2 weeks,
After 2 weeks.
Lordship, kindly
Let this matter appear for hearing on
Lordship in the month of November at least.
24/12/11/2025.
11?
24/11.
24/11. Under the heading hearing.
Under the heading
And
hearing.
Lordship, paper book already been served upon the respondent. I can record that. That paper book already have served.
No, Mr. Singh is appearing for the respondents.
I have served the copy of the paper book upon Mr. Singh.
So very well, unless he disputes that, there is no question of recording. He is not disputing that paper books have been served.
Yes, Lordship.
9 and 10, my lord, I am appearing on behalf of the appellant insurance company. 9 is my appeal and 10 is my learned friend's cross objection. My stay has already been made absolute, my lord, and 1 is
My lord, earlier occasion, my lord, paper book have been filed. But my lord, after that, my lord, a cross appeal has been filed by my client. But that cross appeal has been, my lord, time but delay of 19 days.
Have you filed your application for condonation?
Yes. Can one tell them? Can court can
না দুটো ক্যান আছে।
This my application. Matter is very short point of involvement.
Question is, can application is not appearing, can one too?
Can one is appearing in your lordship list.
all my applications have been disposed of, my lord. My stay has already been made absolute.
No, this can one is condonation of.
Yes, his, yes, my lord.
My lord, the application be allowed and fix for hearing for appeal. Can
Yes,
one
record
আছে?
an order.
Can one আছে?
আর এটা কি অরিজিনালটা? ও আচ্ছা আচ্ছা। Yes, record an order. Learned advocates for the parties are present. As the cross objection Court 114 of 2025 is filed after the period of limitation, the application for condonation of delay which is filed is taken up for consideration. Upon perusing the petition and hearing the learned advocates, it appears that the applicant has furnished sufficient cause for the delay. Stop. Thus, delay in preferring COT 114 of 2025 stands condoned. Let stop. As the paper books have already been filed in the appeal as well as the cross examination, let these matters appear for hearing
On 24
Sometime in December, my lord. My lord has already fixed a lot of matters, my lord, kindly.
2025.
I'm keeping it at the end of November
My lord, my lord.
27,
My
11, 2025.
I'm
Grateful, my lord.
একটা ক্যানই হলো তো, আরেকটা ক্যান earlier disposed.
Eleven, my lord, I am appearing on behalf of the appellant insurance company. My stay had already been made absolute, and on the last occasion, her ladyship was pleased to direct the registrar administration to ensure the appearance of the claimants, my lord, since they were not appearing.
Appearing for the matter.
Item
Yes,
11.
my lord. 11.
Filing the matter, the paper book.
I have received a copy. Yes, I see.
পেপার উঠে দিয়ে my hearing হবে নাকি আজকে date fix kindly fix the date of hearing.
Yes, record and order.
My lord, today I am filing the paper book.
Yes, copy served.
Copy
I have
served.
received.
Learned advocates for the parties are present. As the paper books of this case has already been filed, the paper books filed today be kept with the record. Let this appeal appear for hearing. I'm keeping it on the same day, 27/11,
My lord.
2025, for hearing.
I'm deeply obliged, my lord.
আমি এখানে দাঁড়িয়ে আছি, তুমি দাঁড়িয়ে যাও, নামটা দিয়ে দিচ্ছি, তাহলেই হবে 12 মিনিট। I am appearing for the claimants appellants, my lord. But I have on the last occasion, my lord, I have just filed the paper book, my lord. Your lordships kindly fix the matter any day, my lord. Yes.
Yes, record and order.
Appearing for the insurance company.
Learned advocates for the parties are present. As the paper books have already been filed and served, let this matter appear for hearing on 26/11/2025.
26. একটু আগে করে নেওয়া যায় না, ছোট একটাই শুধু ইনকাম পয়েন্ট আছে।
Income or future cost?
Can it be preponed?
I'm keeping it just after 2 weeks, 26.
My lord.
I'm about to say it. Sir,
In this matter, on behalf of the responding insurance company, Mr. Shomala Ganguly appearing. He's
Item 11.
His clerk has requested to make.
Okay, I'm just making it not today.
Not Passover, he's coming.
Okay.
Quarter.
Fourteen Lordship, I am for the claimant respondent. I have prepared the paper book that I have upon Mr. Singh. Mr. Singh is the appellant. Will kindly fix the matter any day.
Yes, record and order. Learned advocates for the parties are present. As the appeal is ready for hearings and the paper book is already filed, let this matter appear for hearing on, yes, when shall I fix it?
Lordship, 25th, 26th November.
Let us get some breathing time also. We have to study, we have to submit before your lordship. That's
25th or
every
27th?
27th,
25th or 27th?
25th, Lordship.
My lord, whatever he pleases, your lordship will fix up that. If I am not ready, my lord, I'll pray for some time.
Okay, 27/11/2025.
27? Yes. So no question of adjournment.
Item number 15.
Item number 15, my lord, I am for the appellant insurance company. The stay has been made absolute. A date may be fixed for hearing, my lord.
Yes,
Okay.
Lordship, I am happy with the claimant respondent.
Yes, record an order. Learned advocates for the parties are present. As the appeal is ready for hearing
You know.
and the paper books have been filed,
What
let
is
the
that?
matter appear for hearing. Yes, when can you come ready?
My lord, later this month,
End of this month.
my lord.
Okay, 25/11/2025.
Lordship.
My lord. I'm grateful.
Say 16.
16, my lord, I am appearing on behalf of the respondent insurance company, my lord.
Lordship, here I am for the appellant. Lordship, is the is a very so one issue is involved in the appeal. Lordship, kindly turn to page.
No, question is paper books have been filed.
Paperwork files up, everything is complete. I have come before your lordship only with the one issue.
No, you are the claimant.
I am for the appellant.
Claimant appellant.
Claimant. Issue is that lordship kindly turn to page.
So come on Monday, let the matter be, let your learned friend also get
Your
some.
lordship,
It can be disposed of, my lord,
disposed of.
if my lord desires.
Okay. Yes.
Your lordship kindly turn to paper book, page 114.
Yes.
So kindly see that the calculation. Personal deduction, gross, everything all right. But let's see the future prospect, 40% allowed for only 1 year. So it should be calculated
Future prospect.
only. Loss, you kindly see future prospect 40% on of rupees 2,38,810. So that multiplied not used. The learned table ought to have applied multiplier.
So that matter could have been reviewed before the tribunal.
No, Lordship, can appeal court can decide the issue.
No, this is if
Only
it is
this-
error apparent on the face of the record.
So Lordship can dispose of the appeal here and now. Only this is the appeal.
No, the question is.
That is the only calculation.
Yes, what do you say?
My lord can dispose it of. I have made the calculation also in consultation with my learned friend. I have sent him the calculation in his WhatsApp, and the calculation I am trying to upload here also. If my lord so desires, my lord can dispose it off because it's only arithmetical error that 40% future prospect, that amount, it has been. My lord will kindly see it would come to around, after adding this future prospect, my lord, it will come to around 30 lakh and odd. And the learned tribunal has assessed 22 lakh and odd.
So if they rented them 8 lakhs more.
And he is also entitled to interest on.
This is the appeal, Lordship, so can be disposed of.
This is the calculation, my lord will kindly see. I'm trying to upload this.
Okay, that is 40% of 2 lakh. 30.
My lord will kindly come at the figure 21,22,290.
Yes, 22,06,614.
16,000.
22,16,000.
Yes, Lordship.
No, just before that, my lord will kindly see just before that 21,22,290. The line just before that.
As per Pranay Shetty's case.
Yes. So after that, this 40% when future prospect is added, it comes to the future prospect amount is 848,916. That should be added. 848,916 should be added. 848,916.
Only that amount along with
And then it
916.
comes 916. And then it comes to, my lord, 2971206. 2971206.
2971.
206.
And the future prospect comes to 8.
No, yes, my lord, yes. 848,916. And regarding that consortium and all, my learned friend is not pressing that. 70,000 has already been granted. So adding 70,000, the total entitlement, it comes to rupees 30,41,206 after adding 70,000.
Adding 70%.
70,000, that on non-pecuniary damages or general damages, whatever my lord refers to, adding that which has already been awarded by the tribunal.
Total compensation comes to 30,41,206.
My lord, from this,
let it be 30 lakh.
No,
my lord, may I just finish, my lord, once? My lord, kindly. From this amount, my lord, the claimants, they have already received the principal sum of rupees 22,86,614. 22,86,614.
Yes, that means what is the awarded sum?
That is the, yes, they have received this.
Awarded sum.
So the balance comes to 754,592. 7,54,592. So this is this 7,54,592. This is their entitlement along with 6% interest from the date of filing.
This is the case.
So 30 lakh, your compensation amount comes to 30,41,206.
My lord.
And
out of that,
22,86,614 you have already received.
Along with interest.
Along with interest.
So balance 7,54,592. Remaining part, plus you kindly dispose of the appeal by allowing this award along with 6% interest from the date of filing.
Now the question is, instead of this 7,54,592, let it be 7 lakh. It would be a reasonable compensation, but total round figure.
Why lordship will reduce 54,000?
No. Question. So will you be seriously prejudiced if this only 7 lakh is awarded? That is a
lordship, because the Ponoy-Shetty applied the Ponoy-Shetty ratio.
After all, you see, in all cases, you plead that just and reasonable compensation. So instead of going into this 7,54,592,
yes,
of course, then I cannot record
so
consent order.
Round figure is 7,60,000.
My lord will kindly not record consent. This is what he should get, but of course I dispute and I object to his appeal overall.
1,000 would be the round figure.
No. See,
Supreme Court judgment is that more amount has to be awarded. Lordship will reduce that amount because of after.
Suppose 7 lakh is just and reasonable. Suppose instead of 30,41,000, 30 lakh is the reasonable compensation.
May I bring the question with very humble question, lordship?
Because after all, court has to award just and reasonable compensation.
Yes, that is the just and reasonable compensation after applying the ratio of Ponoy-Shetty.
Very well.
So after that, how will we justify the Ponoy-Shetty case?
Question is, you see, in this 30 lakh depends upon the quantum. Okay.
No, lordship, that amount has to be awarded. Otherwise, I cannot give consent beyond the dictum of the apex court. I cannot give the consent. So 7,54,592 is the this is the judgment of the apex court. In view of the apex court, that the ratio has come. Why they will lose 54,000? Under some reason has to be assigned.
It depends upon the quantum. If the quantum is huge.
No, not quantum. One issue is the just and reasonable because of lordship. Suppose some court somewhere awarded, yes, I court awarded, yes, is under 2 lakhs. Some court thinks is under 4 lakhs. But Supreme Court entirely harmonized the entire situation after considering the lordship 34 judgments considered by the Supreme Court in the case of Ponoy-Shetty. After that come to that. So whatever after applying the ratio, whatever amount will come, that will be the just. Whatever amount will be the
court has hardly any scope to decide the reasonable compensation.
No,
simply sit and follow the calculation.
Lordship.
Court has hardly any scope.
No. That's my humble submission. Court has no scope to further interfere after applying the ratio of proportionality. There is no scope. No scope. Because of it can be, if I go to the negotiation or because local law, that is different issue. But once I have come to the judiciary has to, whatever judiciary will found, that will be about it. So the proportionality has to be followed properly, strictly.
What was the multiplier here? 40 into?
Multiplier is rightly applied. Multiplier 18 applied. 8 is.
But only mistake in calculation.
Only that part we have jointly mentioned. That is the only mistake. Nothing mistake is found.
So you see that remedy was available in review.
So lawsuit was of jurisdiction to be issued because of after the judgment, the observation of the learned tribunal that I am challenging. It is not only the arithmetical mistake. If the arithmetical mistake, then I could have filed an application under section 151 of the CPC before the learned tribunal. But here, the observation learned tribunal that I have challenged, where being an appeal court, lawsuit will give a observation that the learned tribunal observation is not incorrect. So correct observation has to be, so the appeal court observation is required. It is not simply as the arithmetical mistake.
So 40% of 2 lakh, it is only.
Everything is all right, only whatever we have jointly submitted, that will be the correct position of law also.
Yes, record an order. Learned advocates for the parties are present. By consent, the appeal is taken up for hearing. It is submitted by the learned advocate for the claimant that the only point involved in this appeal is the calculation of the quantum of compensation by the learned trial court. Learned advocate for the appellant draws attention to the judgment of the learned trial court, wherein the learned trial court has calculated total gross annual income with regard to future prospect by using the multiplier of 10.
Is the multiplier of lawsuit 18.
That is 18, but has not arrived at the correct figure. Upon hearing the learned advocates and considering the calculation made by the learned trial court, it appears that the future prospect amount should come to rupees 8,48,916 and not rupees 94,324. Stop. In the event the compensation on account of future prospect comes to rupees 8,48,916, the total compensation comes to rupees 30,41,206. Stop.
After adding
along with interest.
No, after adding child damages 70,000.
30,41,206 after adding general damages
70,000.
70,000. That is awarded already. Learned advocate for the insurance company, opposite respondent submits that rupees 22,86,614, which was awarded by the learned trial court, along with the interest, has been paid to the claimant appellant. Stop. And if the present calculation is to be accepted, rupees 7,54,592 is due and payable. Thus, this appeal stands disposed. The order passed by the judgment and award passed by learned additional district judge, 3rd Court, Purbo Bardhaman, in MSC case number 25A of 2016 stands modified to the extent that the total compensation which the claimant's appellant would be entitled is rupees 31,41,206.
30, 30, 30 lakh,
41,206.
my lord.
As 22,86,614 is already paid along with interest, the respondent insurance company shall pay rupees 7,54,592 along with interest from the date of filing till realization. Such payments shall be deposited before the Registrar Original site,
Appellate side,
Registrar General,
Registrar
General High Court, Calcutta,
my lord.
in a period of 5 weeks from date.
6 weeks, my lord, kindly, PSU.
6 weeks from date.
Grateful, my lord.
Upon deposit of the said sum, the appellant's claimants will be entitled to withdraw the same, and upon furnishing necessary proof before the learned Registrar General, High Court, Calcutta.
Lordship, the date of filing.
Whatever it is, I've just stated, date of filing till to date.
That is 3rd September 2006. Mention that because it will be easier for the calculation. 3rd September 2006.
From the date of filing, যেখানে লিখেছি না, from the
That is-
date of filing, that is 3rd September 2016 till the date of this order.
My lord, I'll make arrangements so that this calculation, if my lord so desires, it's handed over to my lord's officer in course of the day. Shall I make a?
Observing whatever you have, whatever you
My-
submit, that I have recorded.
I'm great. I'm deeply obliged, my lord. Grateful, extremely grateful.
Yes, I will dispose.
Appeal disposed. I'm abreast.
Passover of Passover. 13 Passover.
13 passed over. Yes. Just call the Passover, madam. 13. Okay. Oh. Oh, what judge? Yes, record an order. This matter is put up for necessary correction in order dated 10/11/2025. The date for listing this matter in paragraph 3 is mentioned as 1st December 2026. Stop. Let it be corrected as 1st December 2025. Stop. Other contents of the order remain unaltered.
Your Lordship, this is my appeal. Your Lordship, on previous occasion, there was a direction given by the coordinate bench of this honorable court to tag the court which has been filed by the respondent in this matter. So if both the matters has been tagged, then it could be fixed for final hearing, Your Lordship. Paper book has already been exchanged between the parties.
Yes, record an order.
Court এসছে?
Learned advocates for the parties are present.
My lord, my court application, my lord, is filed by out of time. There was a delay of.
So let it appear. So is it
No,
held in this application?
Yes, yes, yes.
Is there, Your Lordship?
Court is there, my lord, in this court.
দেখি একটু
68 days delay. Let the delay be condoned.
অ্যাপ্লিকেশনটা কোথায়?
অ্যাপ্লিকেশনটা নিয়ে নাও।
এখানে কোথায়?
আরে নিয়ে নাও না, অফিস কপি দিয়ে দাও। অফিস কপি দেখো।
Oh, have you served a copy of the application?
Yes, yes, Your Lordship. Yes, Your Lordship.
Yes. Learned advocates for the parties are present. By consent of the parties, can 1 of 2025 is treated on the days list and taken up for consideration. The appellant in this application has prayed for condonation of delay in preferring the cross appeal being COT number 118 of 2025. Stop. As the appellant has shown appellants have shown sufficient cause for the delay in preferring this appeal be condoned. Let FMA 974 of 2025 along with what is the number of this court?
What?
Number taboo.
Court number 118 of 2025 be listed for hearing on. Have you filed your paper books?
Yes,
Yes, Your
paper
Lordship,
book.
already
Listed
filed.
for hearing on
24.
24/11/2025.
Deeply obliged, Your Lordship. নাম দিতে হবে তো
Number 18.
18 Lordship, I am for the. Mr. Singh appearing for the Lordship respondents, insurance company, Lordship, the paper book I have filed and served. Lordship, kindly fixed any date, Lordship. Is the issue involved in the appeal? Privacy I am satisfied. Only issue is that the monthly income. I am challenging the appeal. Only the issue the learned tribunal not consider the monthly income properly. So I have to place the evidence.
Yes.
And
Yes, record and order. Learned advocates for the parties are present as the paper books have been filed. Let this matter appear for hearing on after 2 weeks.
As per choice of Mr. Singh, Lordship.
Appear for hearing on 25/11/2025.
Lordship.
Nineteen.
19, my lord, I am appearing on behalf of the respondent insurance company.
19 Lordship, I am for the appellant. I have prepared the paper book that I have served upon the respondent insurance company. Mrs. Paul is appearing for the respondent insurance company. And Lordship, this is the only issue is involved that the learned tribunal, the income is the challenging point, Lordship.
Yes, record and order.
And Lordship, here Lordship kindly see the learned tribunal awarded 4% interest instead of 6% interest. That is the two-fold prayer before your Lordship. Prayer.
Okay. Learned advocates for the parties are present as the paper books have already been filed and the
Filed and
matter
served.
is ready for hearing. Let this matter appear for hearing. Yes, when?
Anytime end of November or maybe December beginning.
On 27/11/2025.
My lord, extremely grateful, my lord.
20. I'm starting hearing of this case. The short point.
You are for the appellant Clement.
Clement. My
You are
client
for the
has
insurance
come with this appeal for enhancement of the award. Under this is a case under section 166 of the Motor Vehicle Act. Under this is a death claim. Claim is about -3 lakh. But the learned tribunal awarded only 55,000. Came under death claim.
Case of 2007.
2007. Now, my lord, 55,000 was awarded arbitrary by submission. No, my lord, income.
So
has
you prayed for 3 lakhs.
paid for 3 lakhs and your lordship, my lord, is award that Nagapapas versus Gudgar, my lord, that is reported in 2003. That the court is not powerless to grant the just compensation, even if the claim amount is lesser than the just compensation. Number here, the claimant before your lordship is the wife of the deceased victim. My lord, what are the grounds, my lord? First, I shall highlight, my lord. What are the grounds? my lord, kindly note it, my lord. Kindly take note, my lord.
Order
What
of
are the
the-
ground? First ground is no loss of income has been assessed. Second ground, my lord, no loss of income.
Yes.
Second,
এই রেকর্ডটা দেখি একটু। হ্যাঁ?
my lord, first ground is
The date of award is
date of award is, my lord, your lordship kindly see.
okay,
the
28 July 2008.
Hmm.
Okay. Yes, what is the ground? Let us see.
First ground is, my lord, grounds in the memorandum of appeal.
Yes. No. Decision.
And what my first is no loss of income has been assessed. The lordship. Second ground is
Now, the Justice S.B. Sinha's judgment came in the year 2008, prior to this one or after this decision.
that is the.
That was the 3000 theory.
3000 theory.
Yes.
That
That
is-
Justice S.B. Sinha's judgment in the Supreme Court,
2008.
sitting with Justice Sirpurkar, that is probably 2008.
Where the accident took place 2004.
2004, right?
Here the accident took place in 2007.
Now, when was the decision made? This is 18th July award.
18 July award, but here the accident took place on 1st January 2007. That is much after banner 2004. So income 100 banner should be is banner throughout. Because banner the income, banner I will satisfy. What
Now,
the-
Pranay Shetty will not be applicable in this case.
Yes, also, Pranay Shetty's judgment is in retrospective. Pranay Shetty's judgment where the accident took place, Malar, in the year 1986. And Pranay Shetty says all the appeals, whether it was pending or Malar.
No, at least you see, if at least Justice S.B. Sinha's judgment could have been considered, then, or if this could have been converted to 163A also.
No, it is a case of 166 because
Or,
my client,
negligence is proved.
yes, negligence has been proved. Now, my lord, your lordship kindly note the note down the what are the grounds my lord taken. My lord, kindly note down. My lord, I'm clearing everything. My lord. First ground is no, my lord, income has been assessed. Only just 15,000 as a my lord, lump sum amount has been given
50,000.
and 5,000 pain and suffering. Total 55,000. So no loss of income has been assessed. Your lordship kindly note.
The findings of the court is there is no loss of income.
No loss of income, my lord. That was not arbitrarily, my lord. Is a mercy. My lord, the Ane Tribunal has said on mercy, I am giving my lord 50,000.
Where is that observation?
Your lordship kindly see page. My lord, page 26G.
Okay.
My paper book. Paper book to be.
আচ্ছা।
Paper book to down.
Yes, paper book, page 23.
Yes, 26G. My lord, the
Page 23.
26.
26G. Is it type copy, the first copy is 30 by 32 copy.
Yes,
That
26.
some details are illegible, that's why.
Yes, 26G.
26.
Yes.
In the light of the above observation and considering all the above facts and also considering the fact the tractor was insured a sum of rupees 50,000 is awarded as compensation to show mercy to the present applicant and also a sum of rupees 5,000 for funeral expenses and pain and suffering. A sum of rupees 50,000 has been granted in favor of the applicant as the final compensation. This is mercy, my lord. The award is, my lord, the London Tribunal has given, my lord, on mercy. But losses, my lord, whenever, my lord, is a, my lord, social welfare beneficial legislation, while it's a special that. So, my lord, if every, my lord, award would, my lord, carry the, my lord, the multiplier.
What according to you should be the award?
Yes, my lord, I am, my lord, kindly noted, my lord, five grounds I have taken, my lord, in this appeal, kindly. First ground, no loss of income, assets. Kindly note it down, my lord, it would be easier, my lord.
No, what evidence did you adduce regarding proof of income?
Income is, my lord, there are three evidences. So, my lord, the oral evidence. The son says that my father used to earn rupees, my lord, 7,000.
And the employer?
Employer now. He was a, my lord,
Cultivate.
he was a agricultural.
Okay.
He used to run agriculture business and a, my lord,
Mosquito net.
and my lord, matchstick business.
Madur.
My lord, your lordship, my lord, second is no multiplier system was followed by the learned time. Second ground. Third ground is no future prospect was granted by the time. That the pronunciation says. And fourthly is no general damage. Only 5,000 on pain and suffering in the case of death. No general damage was granted to the and no interest also. These are the five grounds. Multiplier system, future prospect, general damage, interest, and income. Now, my lord, kindly allow to read the, my lord, the evidence of PW1. There are, my lord, there are, my lord, four oral evidences. One is, my lord, PWS, that is the widow of the, my lord, the disease. My lord, here the disease, Gunodhar Mondal, who was aged about 51 years. As per pronunciation, my lord, the future prospect will be 10%. That I have brought the calculations, my lord. 10% and used to earn, my lord, rupees 8,000 to 10,000. But the learned tribunals, my lord, observe that his income may be, my lord, his income be assessed as 3,000 to 4,000 by, my lord, by doing the agriculture business and, my lord, the matchstick business. It is admitted by the Rana Tribunal, but Rana Tribunal on mercy says that tractor, my lord, in the narrow lane was going, and the disease was riding, my lord, total hypothetical. Disease was, my lord, riding on the tractor, and he fell down from the tractor, and for that, my lord, he was not, my lord, entitled to get compensation as per this section 166. On mercy, though it was a death case, I on mercy, I am giving, my lord, 50,000 as a lump sum compensation to the, my lord, poor widow, and the 5,000 was granted on pain and suffering. These are the observation of the tribunal. Lordship, kindly see the, my lord, PW1, my lord, page 10 to 12. Page 10 to 12 is the evidence of, my lord,
বউয়ের মনে
is a widow. I Dhirenbala Mondo. My lord, she has not, my lord,
No, let us come to the eyewitness.
eyewitness. Eyewitness is, my lord, the PW4,
son of
17 to 18, PW4. Page 17 to 18.
ছেলে
My lord, got it, page 17, paper book.
Yes.
My lord, I see Ajit Mondal, son of late Gunodhar Mondal, is it eventually? That Gunodhar Mondal, son of Gunodhar Mondal, that Gunodhar Mondal, son of so and so and so and so, died in a motor accident on 1/1/2007 at about 9 a.m. near Moshad Pukur Sub Health Center. My father was a cultivator, cultivator, and he had no business of, and he had also business of matchsticks. He earned rupees 8,000 to 10,000 per month from cultivation and matchstick business. That I am the eyewitness of the occurrence on 1/1/2007 when I was going towards our paddy and at the time of my father and one Kajol Patro were sitting by the extreme
left side
left side of the road and taking sun break. At that time, one tractor bearing number so and so was coming rash and manner and injuring human life and safety to the extreme right side and dashed my father and said Kajol Patro. Both of them died on this spot. That postmortem examination was held by the autopsy surgeon of the dead body of my father. That rash and negligent driving on the part of the driver of the office was the sole cause of the accident. That after the demise of my father, the business of the matchstick has totally been stopped. That the statement, this is the manner the examination in chief. But at the manner the cross examination, manner, may I read? States on oath by the cross today after occupying the evidence of PW4. We do not run any mad business. The PO road is narrow village road and and any if one tractor passes through that road, there shall be no space of both sides of the stage road. But my father did not see encroaching that village road. The tractor did not overturn on the spot. The tractor was empty, but the side of the front wheel that touched the armpit of my father. I saw the tractor to come and but I found that my father and after other fellow did not sit encroaching road and the tractor will through said road. Not a fact that I was not present at PO. Case of occurrence, the tractor was not at all fault and the driver of the tractor had no fault, but for our father's fault, they sustained injuries and died. My father had no bank balance or SB account, and my father never purchased my land. Not a fact that my father had no separate income or business except landed property and income business. These are the cross examination of the eyewitnesses. Eyewitnesses is the son of the business who saw the accident. Who Malad told that my father was sitting by the side of the road. taking the mother the sunray, and the tractor comes with ration engine driving, and mother hit my father and his fellow. Both of them mother died on the spot. These are the moreover, your lordship kindly see the charge sheet, the FIR, the documentary evidence. Your lordship kindly see page 50 to 57. Of my paper book. Mother, your lordship got it, mother, the page 51.
Page 50.
Page 50 is a mother, the list of documents, and page 51, I find the certified copy of the charge sheet before the tribunal. Page 51, charge sheet. Charge sheet, mother, this conclusion portion is page 55. Mother, your lordship, mother, got the page 55. Mother, some my witnesses were examined and taken note, and postmortem report, everything mother has, and clearly, and concluding part is page 55.
Yes. Charge sheet was submitted.
Charge sheet. During investigation, a prima facie case under section 279, 304A IPC against the accused Hiren Bolai Manna, son of Suanshu of driver of tractor number Suanshu has been well established. I concluded the case with my Devasis, with my CC and CI Devasis, who were to dispatch me to submit the charge sheet in this case. Hence, I am submitted the charge sheet, by charge sheet number so and so, against the accused Hiren Bolai Chandra Manna, son of so and so. So, Manna, charge sheet, my lord, has been filed by the investigating officer against the accused driver. So, Manna, the documentary evidences also, Manna, prove that there was
So the son of the victim saw the accident.
And the charge sheet also, my lord.
So this is the only one eyewitness.
One eyewitness, and other, my lord, three witnesses. One is, my lord, the widow. My lord, she did not see the accident, so I may not call that she was the eyewitness. She says that my husband died in the accident, and he used to earn rupees 8,000 to 9,000 by doing, my lord, the agriculture business, and, my lord, the Madhur. PWT also, my lord, the same, my lord, the avocation, they PW2 and PW3, they are also saying that we are also, my lord, doing the, my lord, the Madhur business, and we used to earn rupees 7,000, 8,000 or 9,000 per month. This is the oral evidence. My lord, your lordship kindly appreciate there is a lot of judgment of our High Court that oral evidence is a piece of evidence which may be, my lord, accepted if it is, my lord, acceptable or rational, or, my lord, it is a, my lord, in accordance with the law permits. My lord, that is the Bilasini Mondal's case that is reported, though I have not got. That judgment was delivered by His Lordship the Honorable Justice Samaris Banerjee, where the Justice Samaris Banerjee division bench decided over held that in many cases, my lord, supposing a rickshaw cooler, supposing a fish seller, supposing, my lord, a painter, my lord, who has no, my lord, the documents to prove, my lord, their income, the oral evidence is sufficient unless it is rebutted or contradicted by the opposite party. So here, the, my lord, I submitted, my lord, he is a family man, my lord, he has 4 sons. So, my lord, they are not dependent or not dependent, I do not know. There are 4 sons, and my lord, the widow. My lord, at least, my lord, what the learned tribunal at least 4,000 income per month. That is 4,000, my lord, equivalent to, my lord, that is 150, not 150 or 100.
Now, earlier you see, prior to that Justice S.B. Sinha's judgment, that chart was followed. So
Chart.
that schedule.
Schedule is
So
only
that-
confined to 163.
Yes, yes.
But it is a case under section
No, but
166.
you see, in many cases in 166 regarding compensation, that schedule was followed. So if the learned judge would have followed that schedule, how much it would have come?
No, schedule says where the income, no person who has no income. Suppose
Very well, 15, that means 15,000 per year.
that is my lord 1,250.
36,000 per year.
So how much you would have received this compensation?
My lord, here
Yes.
also, my lord, I have only 55,000.
No. If that schedule would have been followed, if that, so 1,000.
Schedule has no application because schedule is only confined to a special section, that is 163A. And now your lordship is adjudicating today while the schedule is not there. My lord, your lordship, my lord, should follow the guidelines or principle laid down by our High Court or the my lord, or at your my lord discretion, what is the just compensation should be granted. My lord, I am not, my lord, paying, my lord, 8,000, 9,000 without any documentary evidence. But at least, my lord, 4,000, my lord, he used to earn, that is rupees, my lord, 165 per day. 165 into 30 comes to, my lord, 4,000. On the basis of 4,000, my lord, I have calculated and I applied the multiplier. Multiplier here, the thesis was aged about 51 years. So multiplier would be 11. Future prospect, এটা একটু দেখেন দর্শক।
Okay, দেখ।
আমাকে আমারটা দিন। Monthly income, I have taken 4,000. Annual income of the business 4,000 into 12, that is 48,000. Future prospect 10%, 4,800. It comes 58, 52, 8,000. And 1/3 deductions, that is 17,600. So balance amount comes 35,200. Multiplier as per age 51 years, Sharala Bharma and Purnashetty 11. That comes 3,87,200. And general damage is 84,000. That is 70,000 plus, my lord, 10%, 10%, 20%. That is 84,000. So total come 4,71,000 minus less awarded amount 50,000. So the balance amount is 4,16,200. That amount, my lord, should be, my lord, granted.
Yes, now the question is if it was treated to be 15,000 also, then also it would have come to some 1,40,000 or something.
Or 15,000, why?
For argument's sake, if it would have been assumed that very well that schedule be followed, then also it could have.
Schedule is, my lord, I am time and again saying schedule, my lord, is to be followed only in case of 163A proceeding. By my case is 166. 166, my lord, has been, my lord, followed the, my lord, the Purnashetty and Sharala Bharma.
In Sharala Bharma also, the discretion was given to follow the schedule, and
I leave it to your lordship. My lord, discretion.
so suppose as per the decision of 2,000, so suppose 3,000 if it is the monthly income, how much it comes? 3,000.
36,000.
36,000.
So 36,000 less 1/3.
I have also, my lord, calculated
3,000. With regard to 3,000.
3,000.
So it comes to 3,19,400.
my lord, monthly income assessed 3,000.
After taking this general damages, Pranay
And date of filing is, my lord, in the paper book, my lord, the certified copy of the claim application, date of filing is 25 January 2007. So on the 55,000, the interest also calculated, and the enhanced amount that was on the basis of 3,000 or 4,000. I leave it to your lordship.
The interest awarded here is 4%.
No interest was
No
granted.
interest. Simplicity principle.
Even if my lord, Learned Tribunal says that the lady should open an account in a post office MIS account, and the insurance company, my lord, that provide the insurance company. The insurance company will do this matter. I don't know, my lord, whether my client has, my lord, received or not. Even if for argument sake, my client has received or invested 55,000. So the figure comes, my lord, on the basis of 3,000, 3,19,400, and together with interest, my lord, 6%. I am reasonable, my lord, submissions.
Okay,
And-
let me hear your learned friend.
Yes.
Yes.
And the case as presented is not as simple as that. I lordship.
No, have you come across this type of observation by, as a mercy, I am giving this type without interest, everything.
Yes.
So I am doing mercy. This
Yes.
person is not entitled at all.
The lordship will kindly go through the entire observations of the learned
Oh,
tribunal.
I don't think it is necessary so much.
No, my lord,
Anyway,
it
you
is
argue with
important.
regard to
It
the
is-
facts.
No, it is important, my lord. After considering.
You see, I am not,
No problem.
these type of observations, doing mercy does not convince the court. Anyway, you argue with regard to the facts, with regard to the evidence.
Your lordship will kindly read from page 26C, decision with reason. Why he has come to this conclusion. Decision with reason. On
Page
proper
26.
study of the application, 26C.
26C.
Decision with reason.
Yes.
On proper study of the application, including the objection and also considering the evidence, including Exhibit 1 FIR and postmortem report Exhibit 4, including inquest report, it is clear that deceased Gunadhar Mondal, son of late Surendra Mondal, aged about 51 years, died due to accident, and postmortem was held on 2/1/2007. And it was found that he sustained abrasion and bruise and bleeding in brain substance in the frontal region was found that it was bleeding from the nostril, but no other injury was found. He was found by the autopsy surgeon. But from the inquest report Exhibit 5, it is clear that only the business or abrasion were found on both of the knees, and on other injury was found on his body by the inquest officer. And from FIR, it is found that FIR made by Topon Patra reported that 1st January 2007 at about 9 a.m. near Mednipur, Kajol Road, and suddenly the tractor, being number so and so, came at a high speed and dashed them on the both side, and both of them died. And no doubt, after considering an argument of the learned lawyer for the applicant and insurance company, and also considering the postmortem report and FIR, it is found that Gunadhar Mondal died due to injuries what he sustained on his head, and that is external abrasion bruise. But fact remains that he sustained some internal brain injuries. Now, but from the evidence, my lord, this is very important. From this portion, your lordship will kindly consider. But from the evidence of witness, PW4, that is the eyewitness, his son, it is clear that at the time of accident at PS, the tractor was passing through the village road, and the village road was too narrow, and there was no space on both sides of the road. And after passing the tractor, but it also submitted by PW4, the son of the deceased, that his father Gunodhar did not sit encroaching the village road, and it has also admitted that he saw the tractor to come, but his father and another fellow did not encroach the road, and the tractor went through the said road. It is evident of eyewitness that his son of deceased is considered. It can safely be said that tractor did not dash the present deceased and was not run over by the tractor.
No, if it was so much convinced that the accident did not take place, what was the necessity to avoid damage at all? The case should have simply dismissed.
Kindly go through. Your Lordship, you will understand
Why?
everything.
You see.
It is very interesting.
No, if
How
it,
the-
was,
how-
was
how
there,
the
was there
case
any
was-
necessity to pass any award?
How-
Its simplicity could be thrown out.
No. The case was absolutely manipulated.
The case could have been thrown out.
Your
With
Lordship,
costs.
yes, follow the.
So where is the scope of sympathy then? This the court does not have the sympathy
This
jurisdiction.
50,000 granted is enough, my lord.
It could not have been granted if there. It could have
That
been
is up to your
simply
lordship.
dismissed.
That is up to your Lordship.
No. Question is.
Your
so-
Lordship is sitting in
so-
appeal.
No. Question is, if the court is confident, then that amount should have been dismissed.
Yes, your Lordship will kindly go through.
But you see,
his
see
observation.
the legislation. What is this motor vehicles legislation? What is the purpose? Whether there are so many decisions that it is not necessary to prove beyond reasonable doubt.
Claimant has to establish his case.
Yes. What more the claimant will do apart from this?
If the my lord, the victim had fell
Apart-
down from the tractor.
apart from
He
this-
was riding the tractor. He fell down from the tractor.
No,
The
question is-
tractor did not dash him. Kindly.
Question: where is that evidence? The opposite party adduce any evidence that?
Yes.
No.
The postmortem report itself says.
Where is the postmortem report? Let us see.
The postmortem report says there is abrasion in his head.
Whatever it is,
Forehead.
where is that? That he was not.
But
the
eyewitness-
tractor did not dash him. Where is that postmortem report?
Page 41 to 45.
Eyewitness,
Postmortem
PW4,
41
he
to
says
45.
tractor dashed him, touched his armpit. He was sitting, victim was sitting on the roadside and the tractor touched his armpit.
That means accident took place. You see.
He was not run over.
No accident. If accident has taken place, that is also an accident.
Is this an accident at all?
No.
No accident. He
Dashing-
fell down from the tractor and died, my lord,
Where is that finding?
because of head injury.
No. Yes. What is the hospital? Where is that postmortem report? Postmortem report is not here probably.
Yes,
It was
page-
exhibited.
Yes, exhibit 4, page 41 to 45.
Page 41.
To 45.
Page 41.
Now page 41. Yes.
Yes, page 41.
My learned friend says, date of commencement of autopsy, that is next date. Disease died on 1st January.
Yes.
Name of the disease mentioned Gunodhar Mondal.
Learned trial judge had followed everything, lord.
No. What is let us
Thereafter, he is
let us see
making
the
his
report.
observation.
Let us see the report.
That will be easy, my lord.
No, no,
Follow
let
his
us-
observation. Thereafter, if your lordship wants to modify, I don't mind.
No. What is
But
the?
his observations are very particular and specific.
Let us see.
Page 42, last portion, my lord. Head. Page 42, last portion. Last paragraph. Number 1, head. Scalp findings, abrasion and bruise over frontal region. Last portion of page 42.
No, regarding injury, particulars,
Yes.
particulars of the injury.
Yes, head. Number 1, head. Scalp findings, abrasion and bruise over frontal region. skull.
This person, how can this person drive tractor? Was he
He
authorized to
was
drive?
not driving, he was riding.
Where it was proved?
He was in the tractor, driver was there.
No, where is that evidence?
That is his assumption.
Assumption.
Where is that evidence? You
From
see,
the evidence, Milord,
suppose a person is driving, he must be authorized to drive. If
No,
he
no.
is a gratuitous passenger, that is another thing, okay? But
my
where is
lord-
that evidence that he is a gratuitous passenger
my lord, it is
in the
evident
tractor?
from, it is
He's not
evident from the
passenger.
facts. It is
Where? Which fact? You see, let us
that
see
he
the
is a
nature of
cultivator.
Yes,
He is a cultivator.
very well.
He, Milord, took the tractor to his field. He was taking the tractor to his field to
Where is
cultivate.
where is that evidence? You see, if it is own
Your
tractor,
lordship has to draw your lordship's inference, Milord.
question is, you see, the where is, first of all, you see, let us see where the accident took place. Thereafter, you see the nature of the injury.
This is manufactured case, Milord.
You see how you can presume like that. So what does the charge sheet say?
Charge sheet says that is the conclusion of
The
investigation.
findings in the charge sheet, what is the charge sheet?
That is my lord, page 57.
Yes.
Milord, charge sheet, FIR, everything was followed by the.
No, let us see. Let us see. What does the charge sheet say?
After following his observations, his.
You see,
Thereafter,
the
if necessary,
observations
we'll go to that.
Observations will come after on the basis of these documents and the evidence. Let us consider this evidence.
Whether his observations are conclusive or not.
No, let us see. Let us see.
That also your lord.
No, what does the charge sheet say? Page 57.
Page 57. অদ্য 1/1/2000 তারিখে সোমবার সকাল নাগাদ
9টা নাগাদ
সমস্ত
কি মাসাস্ত পুকুর থেকে
দেউলিয়া
মোড়া রাস্তার
নিউজটি পুকুর উপস্থিত সেকেন্ডের সন্নিকটে আমার পিতা মানে
No, this is the complaint.
This is the complaint. My lord, the 2% died, and my lord.
Where? Which place? Where is the charge sheet? Then let us see. We'll find it. Okay, yes, during investigation.
Yes, during investigation. Page 54.
55.
55 এর পরেরটা পড়ে।
No, yes, 54.
এখানটা লেখা আছে observation.
During investigation, I visited the place of occurrence and sketch map, and so and so, and available witnesses, and hence 161 statement. Gunodhar Mondol and Kajol Patro. Bodies of a subdivision hospital for postmortem examination. Sees the
After how many days? On the deception date, this person died?
No.
Yes, broad date.
Broad date, but postmortem was held on 2.
2nd January.
And after how many days this FIR was lodged?
On the same day?
Same day, that is, the date of incident is 24/2.
No.
No.
1/1/2007.
1/1/2007. Okay. This is the date of 1/1/2007 is date of lodging this complaint as well as the date of accident.
Date of accident.
And my lord, on the date of accident, it was lost. Kindly see page 34.
Acha, against whom this 304A charge sheet was given? Driver of the tractor.
Driver of the tractor. Is everything clear?
How many persons died? Only one person.
2%.
2 persons died.
Kajol Patro and my lord, the Gunodhar Mondol.
So any other complaint, any other claim case with regard to the other victim?
No. Other victim, that I do not know.
Okay, so Kajol Pacho and Gunodhar Mondal died.
Right.
So does the complaint say anything about two persons?
Yes, yes, yes.
That the death of two persons, that who was sitting in which place?
Your Lordship, kindly see page 35.
No. Yes, page 35.
No, it is alleged both were sitting by the roadside.
Yes.
What for my learned friend, my lord?
Just a minute. Page 35.
পেজ 35 আমি নিম্ন সাক্ষ্যকারী তপন পাত্র পিতা কাজল পাত্র থানা অন্তর্গত 3 নম্বর দাবরা অঞ্চল গ্রামে অধিবাসী হইতেছি অদ্য 1/1/2007 তারিখে সোমবার সকাল প্রায় 9টা নাগাদ মাসানপুর থেকে দেউলিয়া মোড়া রাস্তার ধারে নবনির্মিত সামন্তপুকুর উপস্থাপন কেন্দ্র সত্যিকটে আমার পিতা কাজল পাত্র এবং নানাকা নীল গ্রামের গুণধর মণ্ডল রাস্তার ধারে রৌদ্র পোয়াইতেছিল। ঠিক এই সময় ডব্লিউবিএন একটি ট্রাক্টর উল্লিখিত দুজনকে সজোরে ধাক্কা মারে। এই উভয় ঘটনাস্থলে মারা যায়। উক্ত গাড়ির ড্রাইভার পলায়ন করে। অতএব মহাশয় নিকট আবার on the same date of accident FIR was lodged
and the charge sheet was submitted against the vehicle, against the driver of the
vehicle. Everything is clear.
Another thing is
Apart
this,
from him, my learned friend inferred the presumption, assumption.
no owner of the tractor. So you see, just a minute.
He did not summon.
No. Question is, suppose a person is not the owner of the tractor, why he will sit in the tractor? So
Driver was not sitting. Driver was sitting.
the driver was charge sheeted. Okay, driver was charge sheeted.
Yes.
So the question is, according to you, he fell from the tractor.
Yes.
So why this person will sit in the tractor if the person is not the owner of the tractor? That is the question.
He was taking the tractor for plowing his field.
Why? Plowing is
Cultivator.
No. If he takes the tractor, suppose.
Hired.
Yes.
Hired the tractor for
Where do we get that? He has had that tractor.
That is clear, my lord.
No. Question is, you see, we cannot assume in that way. Suppose the person drives the tractor. He must be the owner of the tractor, or he must be authorized to drive the tractor.
Not at all a driver. He was not at all the owner. He had hired the tractor for cultivation of his land.
So he was
taking the tractor.
No, in your written statement, was that the case? In your written statement?
From their evidence, it is palpably clear, my lord.
Now this is, you see, just a minute. This is that means according to the FIR, it dashed. Okay. Now from which portion of the cross-examination do we get that this person was sitting
From
in the tractor?
Postmortem report, the abrasion from dashing, tractor
You see,
dashing a person on the side, that cannot cause his brain abrasion.
The question is whether he met with an accident, but he died on the same date.
Yes.
And not only he, I think two persons.
That is why your lordship has to follow the.
Yes. Which report you want to rely? Which page? This postmortem report.
Yes. Head যেখানে দেখালাম. Shown your lordship.
That is
54.
মাথায় চোট লাগতে পারে না একটা গাড়ি যদি একজনকে ধাক্কা মারে
তার বগলে টাচ করলো তাদের মাথায় চোট লেগে যাবে।
কে বলেছে বগলে মেরেছে?
তোমার আই উইটনেস বলছে।
আই উইটনেস?
হ্যাঁ।
বগলে মেরেছে আই উইটনেস? কি পড়ো তুমি আজকাল উল্টো পাল্টা বলছো।
No, just a minute.
বগলে মেরেছে।
Okay, page 54 is the charge sheet.
হ্যাঁ।
No, the postmortem report that is there.
না কোথায় একটা হেড বলে দেখ।
খেয়ে দিয়ে আসুনি পেট এমটি স্টমাকে এসব বহুতবার আর্গুমেন্ট।
Okay, inquest papers mentioned, that is.
কিছু তো আসতে হবে।
Okay, this is so let us consider once again the cross examination of this PW1.
PW4.
Huh. So PW1 is what? The complainant.
PW1 is the complainant. She's
No. PW1 is the
claimant.
Claimant.
He did not see the accident.
He did not.
PW2.
PW2 is the one that he was carrying the Madhur business.
No, PW2.
PW2.
Another person carrying on.
He tried to prove the income of Gunodhar Mondal.
Okay, that is PW2.
PW2 and 3.
PW2 and 3. So
but PW4 is the son of the deceased who was the eyewitness, who narrated
Okay,
the
so let us
manner of
consider
accident.
the cross-examination.
Yes.
Yes.
Again.
Now,
Cross-examination.
page 18. Page 18. Very first line, he is saying, we do not run any business.
No question of any
Therefore,
business.
that match
Very
the-
well, he has no income, but only let us see with regard to
we
accident.
don't run any business.
Run any
Question of
business,
Very well, some
Run-
notional income will be taken into consideration,
Yes,
but
that-
only after the accident is proved. Let us see the evidence with regard to accident.
My lord, it's a joint family. He died at the age of 15. He had 6 issues, 4 sons and 2 daughters. All are married. Sons are also married. So
You
they are
see, here you see, regarding income, there are different decisions. Notional income can be taken into consideration, but after the case is established, only question of this notional income and all these things comes after he has been, this case of accident is established, not before that. So let us see whether this person, claimants have been able to establish or not.
Yes, that is the thing.
So that let us come to the cross-examination again.
So PW4 says we do not run any business. Therefore,
we do not
matchstick.
any mad business.
Mad
Just
business.
a minute, page
Therefore,
26.
page 18, cross-examination.
Page 18. Yes, page 18. Yes. Okay, we do not run any
Not
mad
run
business.
any mad business.
Yeah.
So your business golpo goes.
Yes.
Agriculture business goes.
Anyway, I am throwing out all business and income. Just I am confining myself to the accident.
He was having 8 to 10 bighas of land for
Yes.
cultivation.
You
He is a
leave aside
cultivator, born and
everything.
brought up as cultivator.
Very well. You leave aside everything. He has no income. He was an unemployed person. Let us see whether the accident took place or not.
I am presenting the case in my own way.
Yes.
Kindly appreciate that.
Yes.
His sons, they are carrying on the cultivation. Therefore, there is no loss of his income. No loss of income at all. All sons are carrying on the cultivation.
কোথা থেকে পেলো
এই তো লেখাই আছে।
Anyway, just. Yes.
Last para. My father had no bank balance. Last page 18. আচ্ছা, গোটাটাই let us read entire page 18.
বাংলায় যখন আর্গুমেন্ট করছো বাংলায় বলো না, অর্ধেক বাংলা অর্ধেক ইংরেজি কেন বলছো?
The place of occurrence road is so narrow village road, and if any tractor passes through that road, there shall be no space on both sides of the said road. It is so narrow. On that narrow road, the tractor was plying. Now, if a tractor is coming, making sound, they are sitting by the side of the road. They will not stand up and
আরে রোডের মধ্যেই তো ট্রাক্টর এসে
but my father died on spot. My father did not sit encroaching that village road. He was not encroaching the road. However, he was sitting by side. According to PW4, the tractor did not run over, overturn on the spot. The tractor was empty, but the side of the front wheel touched the armpit of my father. Touched the armpit of my father. Can that cause his brain abrasion? Postmortem report says he had forehead abrasion.
Is there any evidence that after that accident?
Postmortem report says.
After the accident, oh, he died on the spot.
Yes.
So in which hospital? Oh, so he was not. There was no scope to take him to hospital also.
No, he was taken to the hospital.
Yes. He was taken to hospital.
Card, yes.
Yes. Which paragraph? Yeah. Yes.
No, postmortem was held at Kharagpur subdivision hospital.
Kharagpur. No, after the accident, he was taken to hospital.
Hospital immediately. And broad dead. Report is broad dead.
So not only this person, but 2 persons were taken to hospital.
Yes.
However, we are concerned with this claimant,
No, but
this person.
So the case of the police authority is concerned, 2 persons were taken to hospital.
Yes.
Yes. Whatever. that is not mentioned. In our report, we find Gunodhar Mondal, dealing with Gunodhar Mondal.
Claim of Gunodhar Mondal, but accident, the person's names are mentioned who met with an accident. Okay, the person's names are mentioned, the persons who met with an accident, the persons who were taken to hospital and died.
Yes.
Okay.
And
this is the position.
Son says, I saw the tractor to come, but I found
another fellow.
I found that my father and another fellow did not sit encroaching the road, and the tractor went through the said road, not a fact that I was not present at place of occurrence, and tractor was not at fault, and the driver of the tractor had no fault, but for our father's fault, they sustained this injury and died. My father had my father had no bank balance or savings bank account, and my father never purchased any land. So it is all inherited. 8 to 10 bighas of land he was cultivating, all inherited. So after his death, his sons are also carrying on the cultivation, their source of earning as. Therefore, your lordship will kindly go through page 26D onwards. The observations made by the learned trial judge is very specific and clear. That will take your lordship to reach to assess the case properly. What was the point of consideration? What facts he considered at all? So I'm reading from page 26D. Your lordship will kindly go through. It will be easier to understand. But from the evidence of the witness PW4, it is clear that at the time of accident, PS, the tractor was passing through the village road, and the village road was so narrow and there was no space in both sides of the road after passing of the tractor. But it is also admitted by PW4, son of the deceased, that his father Gunodhar did not sit encroaching that village road, and it was also admitted that he saw the tractor to come. But his father and other fellow did not encroach the road, and tractor went through the said road. If the evidence of the eyewitness, that is son of the deceased, is considered, it can safely be said that the tractor did not dash the present deceased, was not run over by the tractor. When that is the fact, that it is clear that some other incident took place and this tractor was included as offending vehicle. That is why I am saying this is a manufactured case, including the offending vehicle. But PW4 has tried to say somehow or otherwise that the side of the front wheel of the tractor touched and dashed the armpit of his father. So how his forehead will be injured? That means invariably he was within the tractor. This is the inference. Why? That means invariably he was within the tractor, and tractor was proceeding through the village road, and when the tractor was toiling due to uneven mud road, he fell down from the tractor and sustained injuries. This is ample, my lord, clear to understand what actually happened. But PW4 has suppressed, and only to grab compensation, this story was included in FIR. Whatever it may be, it is clear that Gunodhar died due to sustaining some injuries on his forehead, and invariably such sort of injury must be found in case when anyone falls from any height on the mud road, because the injuries are found on the person of the deceased. Gunodhar is very simple, that is abrasion or bruise on his forehead, but no other injury was found by the autopsy surgeon externally. But after dissection, internal blood clot inside the brain was found. Then it is clear Gunodhar was in the tractor and he fell he fell down on the track from the tractor, and there is no other person to ride in the tractor and to proceed with the tractor. But in the village, it is found that cultivation are the proceedings to the field on sitting in a tractor for cultivation. But he had hired the tractor.
Regarding the autopsy surgeon report, let us come once again. Let us.
বলো না কত পেজ?
Inquest report is page 46 to 49.
Inquest report, that is the Shrothal report.
Yes.
Yes.
46 to
46. Yes. That is, yes. This is the recording by the magistrate.
Investigation report.
No, this is 174.
কিভাবে মৃত্যু হয়েছে ডিউ টু রোড ট্রাফিক অ্যাক্সিডেন্ট?
মৃতের নাম হলো, ঘটনাস্থল হলো, মৃত ব্যক্তির বর্ণনা।
So two reports were held, two inquests. That is one with regard to this claimant, this victim, and the other was regard to the other victim. But in the as per the complaint and as per the charge sheet, 2 persons died.
Yes. And they have never produced any documentary or.
So regarding here, what do you say?
মৃতের অবস্থান মহন্তদেব মন্ডল থানা ইত্যাদি আশুতোষ পাল চৌধুরীর সাথে লইয়া আজ 1/1/7 তারিখে বিকাল 5:25 সময় মাসন্তপুকুর উপস্বাস্থ্য কেন্দ্র কাছে অস্পষ্ট মৃত গুণধর মন্ডল, বয়স 51, পিতা মন্ডল নিয়ে থানা সবং মৃতর প্রতি সম্মান প্রদর্শন করিয়া মৃতর কি সুরহাল প্রস্তুত করিয়া প্রবৃত্ত হইলাম। মৃত গুণধর মন্ডল মাসান্ত পুকুরের কাছে মোরাম রাস্তার উত্তর দিকে, উত্তরে মাথা, দক্ষিণে পা, অস্পষ্ট বাম দিকে লম্বালম্বি ভাবে দেখা গেল। মৃতের চেহারা মাঝারি, চুল কাঁচা পাকা, চোখ দুইটি অর্ধ খোলা, মুখ অর্ধ খোলা, ডান হাঁটুতে দাগ দেখা গেল। আপাত দৃষ্টিতে মৃতের শরীরে আর কোনো দাগ দেখা গেল না। মৃতের পরনের পোশাক ইত্যাদি। উচ্চতা 5 ফুট 6 ইঞ্চি, শরীরের গঠন মাঝারি ইত্যাদি। মৃতের শরীরের কোথায় ডান হাঁটু ও 2 হাতের অস্পষ্ট দাগ দেখা গেল। আঘাতের চিহ্ন ও তাহার মাপ, অস্পষ্ট দাগ দেখা গেল। আপাত দৃষ্টিতে আর কোনো দাগ দেখা গেল না। ওই সমস্ত আঘাত কি প্রকার? ট্রাক্টরের ধাক্কায়। সাক্ষীদের ইত্যাদি। কি সাক্ষাতে কি জানা গেল? মৃত গুণধর মন্ডল আজ সকাল 9টার সময় কাজল পাত্রর সাথে পুকুরের উপস্বাস্থ্য কেন্দ্র সামনে মোরাম রাস্তায় রোদ পোয়াইতেছিল। তখন একটি ট্রাক্টর তাহাদের ধাক্কা মারে, দুজনের মৃত্যু হয়।
Oh, that means 2 persons.
2 persons. প্রাথমিক তদন্ত সাক্ষীদের নেক্সট পেজ মিলন। প্রাথমিক তদন্ত সাক্ষীদের জিজ্ঞাসায় জানা গেল মৃত গুণধর মন্ডল আজ সকালবেলায় উপস্বাস্থ্য কেন্দ্রের কাছে মোরাম রাস্তার পাশে রোদ পোয়াইতেছিল। তখন একটি ট্রাক্টর, যাহার নাম্বার এত, ধাক্কা মারলে গুণধর মন্ডলের মৃত্যু হয়। তবুও মৃত্যুর সঠিক কারণ নির্ধারণের জন্য মৃত গুণধর মন্ডলকে থানার ইত্যাদি দিয়া হাসপাতালে ময়নাতদন্তের জন্য পাঠানো হইল। তো এটা তো দিস ইজ নট কনক্লুসিভ।
মানে কি কনক্লুসিভ তোমাদের এভিডেন্স আছে?
Yes, so the thing is this PW4 cross examination that has to be taken into consideration along with this corroborating documents.
Therefore, entire case is manufactured. He fell down from the tractor. That is why he got head injury. Case has to be assessed from the fact. Whatever he says, many things is untold. The learned trial judge considered many aspects. That is why he made his so many observations. Your Lordship has to go through that observation. Thereafter, whatever inference your Lordship will draw, I'll not stand in the way. But I must present the entire case before your Lordship. So kindly, we are reading 26E. Whatever it may be, it is clear that Gunodhar died due to sustaining some injuries on his head, and invariably such sort of injury must be found in case when anyone falls from any height on the mud road. Because the injuries are found on the person of the deceased Gunodhar is very simple. That is, abrasion or bruise on the forehead, but no other injury was found by the autopsy surgeon externally. But after dissection, internal blood clots inside the brain was found. Then it is clear Gunodhar was in the tractor. Then it is clear that Gunodhar was in the tractor and he fell down from the tractor, and there is no other person to ride in the tractor and to proceed with the tractor. But in the village, it is found that cultivation are proceeding to the field on sitting in a tractor for cultivation purpose.
Just a minute now. The another thing is this inquest report. There is injury in the arms. In the autopsy surgeon report, is there any injury in the arms?
Injury on the knee,
No,
on
no.
both the knees.
That is there. Okay. In inquest report, there is injury. What was apparent
That
is
is
injury.
the story made by the
No, no.
claimant. The tractor pushed him from
No,
the.
suppose inquest, it is found, you see, from the body.
Yes.
What is found from the body inquest? The injury, that is injury in the arms. Arms as well as this.
And the knees.
And the knees. Yes, which page again?
Oh, yeah. Inquest report, page 46 to 49.
46 to 49, yes. So in inquest report, you see, there is injury 49.
My lord, your lordship will kindly read from page 42.
No, 42.
Head.
No, in this case, you see, inquest report, that means after putting the body, making the body lie on the field, it was observed that, yes, knee, then hands also. Here it is found knee and hands. Anyway, with regard to this brain, it is not possible. That is the task of autopsy surgeon. Now 42. Okay, let us 42. See. Yes.
Last para. Number 1, head. Scalp findings. Abrasion and bruise over frontal region. Skull. Described fractures and them on body. Enclosed. Intact. Skull intact. Meninges. Meningeal spaces and cerebral vessels. Location, abnormal smell, etc. Noted. Blood in brain substance in the frontal region. Brain findings and weight. Orbital, nasal, and oral cavities findings. Blood in nostril. The eyewitness says it was
okay,
a
neck. There is okay.
Push from side.
No, neck. It is there. The
why...
chest fracture, ribs. Okay, abdomen. Anyway, abdomen is not involved here.
Unless a person falls from a height, these things cannot happen. So he was in the tractor and fell down from the tractor.
Let us see.
Why he was in the tractor? He hired the tractor to take to his field for cultivation.
কোথা থেকে বলছো হার্ট ফগ দি
আরে তা নাহলে সে ট্রাক্টরে চড়বে কেন?
Okay, the cause of death to best of my knowledge and belief is shock due to the above mentioned injury and intracranial hemorrhage. Anyway, injury, but which portion of the injury?
Injuries. So from the side push, according to PW4, the tractor pushed him from the side because he was not encroaching the road but sitting on the side of the road. রোদ পোয়াচ্ছিল। Even
But
after
here,
hearing,
of course, it
the
is not
tractor is
mentioned.
coming with such a
Which
sound.
injuries are anti-mortem or post and duration, if manner of causation of injuries, whether injuries anyway are sufficient to cause death in ordinary course. Something apart from this evidence, the other has to be established by oral evidence.
Therefore, the tractor was not at fault. Driver was not at fault. He himself fell down from the tractor.
Shock due to above mentioned injury. Okay, that is there. Injury is there.
That is why I'm.
No, here you see one thing, this injury in the arms, it is not observed. Injury in the arms.
That is why I'm beseeching your lordship to go through the observations made by the learned trial judge.
I'm just going through this report.
Thereafter, it will be helpful for your lordship to see, I mean, verify it from the postmortem report or FIR or whatever. How much his observations are telling or logical. Really, it was a mercy case. Learned trial judge granted 50,000 rupees just for mercy. No case established. Total manufacture.
Yes, there is mention abrasion and bruise left arm below.
From PW4 evidence, my lord, this does not say
that the nature of injury, which place? First of all, which place? And here I find also there is abrasion and bruise left arm below eye, right eye and forehead.
Therefore,
Arm, eye and forehead, these three places.
he has fell down. He had fell down from the fallen down. Otherwise, this type of injury cannot cause.
So where do we get that in the postmortem, in the autopsy surgeon report, that these are the possible only when a person falls down? This type of injury, where do we get from the report? It is stated that cause of death to best of my knowledge and belief is shock due to above mentioned injury.
Yes.
Particulars and intracranial hemorrhage. So the causes of this injury when the person falls, where do we get that?
That is
whatever must be there should be observed by the report autopsy surgeon.
From the report, we do not get it specifically.
No, otherwise how can we, you see, infer then?
This presumption can be
No, why? From which source?
Unless a person falls from a height.
Yes, that means, you see, that means that particular medical medical book, that medical terminology has to be recorded on the basis. Because you see, the autopsy surgeon has recorded all these things. He has stated the cause of death to the best of my knowledge. And belief is shock due to above mentioned injury and intracranial hemorrhage. He has not gone into all these things, that this is possible, that only when a person falls and not otherwise.
It is understood, my
lord.
From the
it is, if these are caused by falling and not otherwise, then no question, he could have observed that. So anyway, these documents, documents as well as this cross-examination of PW4
does not match, my lord. PW4 evidence with this autopsy report does not match. That is why I am submitting, my lord. The case is manufactured for their, my lord, advantage. Now your lordship will kindly go through the entire judgment. It will be palpably clear why he had come to this conclusion, that yes, it's a case of mercy. Cannot be granted any award. All right, I'm giving you 50,000.
Okay, that's all.
I'm great.
Yes.
Lord, one thing, my lord, I have gone through the lower court record. Even if my client has not received 55,000, they have not deposited.
Anyway, you have challenged this. That is why they have not.
I have not given interest.
No, my lord, the learned tribunal observed in the post office, insurance company will, my lord. Thereafter, there is no report that insurance company has opened the the MIS account in the post office.
That you will obtain instructions. Both of you will obtain
No,
instructions.
no. My lord, if your lordship
Not the duty of the Lord learned court to deposit the money in the.
Even if, my lord, for argument says my
He
client
deposit.
my client
He will
will
collect.
execute the 55,000, my lord, that award. But the award which is, my lord, going to be passed, my lord, that I am submitting that on the basis of 4,000 or 3,000 and applying
Nothing
the
of that.
Sharla Pharma.
No law is
My
abstracted.
lord, there is no evidence from the insurance company, either by oral evidence or from documentary evidence. It transpired that he had the tractor. He fell down from the tractor, and there is no ration negligence. My client, my lord, proves, my lord, the ration negligence driving of the driver of the by way of oral evidence and documentary evidence. Documentary evidence and everything. Income, my lord, there is no documentary evidence, but the two person has come and reported that we are doing, my lord, the agriculture and matship business, and we used to earn rupees 8,000 to 900. His, my lord, Vinod Mandur wife says that my husband used to earn rupees, my lord, learned tribunals observe, kindly, my lord, see that his income may be, my lord, 3,000 to 4,000. That can be considered. But case is that he, my lord, this is a case where he fell down from the tractor or otherwise. My lord, that's why I am giving, my lord, 50,000 plus 5,000 on penalty. This is on marks. This is the observation of the tribunal.
Yes, learned advocates for the parties are present. Hard learned advocates. Hearing is concluded. Let this matter appear for judgment on. এইটা ডেট দিয়ে দিই একটু শুনে পেয়েছি। ডেট বলে ফেল 26/11/2025
Judgment. Well contested. আমি কিছুই বলিনি, এক বলছি।
Item 21, my lord, I am for the respondent insurance company. My lord, I have misplaced my brief. My lord, I am praying for not today only.
Oh, my lord, this, my lord, it has come at my instance. My lord, I have some documents, my lord.
So your learned friend is not ready today. So I'm just making.
One thing, my lord, whether NCR, my lord, has been briefed to the honorable.
So paper books are ready.
No,
A
paper
note,
was ready.
but no exhibit document.
এই order sheetটার মধ্যে দেখো না আছে।
Call for হয়েছিল একবার order sheet
Order sheetটার মধ্যে call for হয়েছে।
Call for হয়েছে।
তারপর দেখো দেখো না তারপরে কি এইগুলো দেখো না।
নিচে যাবে কেন?
কবে কল for
আবার একটা কল করে নিয়ে করো।
Malar, I pray, Malar, there is a direction upon the Prime Minister administration of department. Malar, to bring the Malar draft report from the child.
By special messenger costs.
Special messenger cost of posting in the food. Yes, Malar, as you lost.
Yes, record an order. Learned advocates for the parties are present. Let the trial court records be called for by special messenger costs to be furnished by the opposite respondent.
No, appellant.
Oh, appellant.
Appellant.
Let this matter appear on 28/11/2025. Let this matter appear on 11/12/2025.
And Malar, special messenger.
Yes, yes, to be borne by the appellant.
Yes.
I'm grateful, my lord.
25. My lord, item 25. Mrs. Paul is there, and my lord, for respondent, Mr. Abu Abbasuddin is here. Mr. Abbasuddin has not come to the court. My lord, he has requested
today.
My lord, he has requested to make it not this week. My lord.
Okay, not this week.
I'm grateful to your lordship.
27.
Not today.
28. And for the
And for the respondent claimant.
I'm for the appellant, make it not today.
27. Not today, not today.
My lord, interim stay was granted on 21st May 2024. My lord, interim stay was granted. My lord, I have secured the entire awarded sum together with interest before this honorable kindly dispose of my stay application.
Stay was 21st of June 2024 up to.
Huh? No, এই হবে।
Okay, you have deposited the entire sum.
Interest sum, interest. এর করেছিস? হ্যাঁ? এবার রেডি করে
তোমাকে ডেলিভারি দিয়ে আছে
তাই
ওটাও জমা আছে তো পেপার বুক
ফাইলে
হ্যাঁ আর্টস টয়েল আর্লিয়ার অর্ডার ইজ দেয়ার
ফাইলও আছে।
Yes, record an order. Learned advocates for the parties are present. As the appellant insurance company has already deposited the awarded sum in terms of order dated 31/5/2024, the judgment and award passed by learned additional district judge, first track, first court,
না না কি একটা
first track, first court, Bardhaman.
বর্ধমান
In this was undivided Bardhaman. when it was passed probably.
Yes, yes.
In MSC case number 53 of 2016 shall remain stayed till disposal of the appeal.
This my lord, paper book has.
As the paper book
This my lord,
are
paper book
filed,
has already been filed.
as the paper books have already been filed, let this matter appear for hearing on 27
November.
Okay. 3/12/2025.
3/12/25. Right.
Very good.
তোমার কাছে স্টেপলেশন কথা মনে আছে
লাগবে তো?
না না ডিসপোজাল হয়ে গেল তো
হ্যাঁ।
29.
My lord, I am appealing for the behalf of the appellant, my lord. Paper book already served to the other side, my lord.
Can 1 of 2022 disposed already?
Dispose on 5 Jan 2023.
Yes. Record an order. Learned advocate
My lord,
for
paper
the
book be kept on record.
appellant is present. Learned advocate for the appellant files the paper book. Let the same be kept with the record. A copy be served upon learned advocate for the respondent. Let this matter appear for hearing on. When can you come ready for hearing? Next week?
My lord, this week.
19/11/2025. The learned advocate for the appellant is requested to intimate the other side by notice.
Also, I am for the claimant respondent. Mr. Singh prefer an appeal favored by the insurance company. Lordship, during pendency of the appeal, one of the claimant respondent died. Also, I have taken out one application for substitution of the claimant respondent number 4.
That is
Can Lordship 3.
And can 2 is for?
Can 2 is for Lordship the application for withdrawal that I will place at the time of hearing, final hearing.
Yes.
Today I am not placing that. So that the application 3, kindly Lordship consider that. Lordship, kindly the this died Lordship intestate. One of the is Lordship, kindly see the page 4. Lordship, got the application for
yes, para 7.
Paragraph 7. The Nomita Singh, that name has to be inserted in place of Ajanta Singh. Others, all legal heirs are already on record. And I have also annexed the death certificate of Ajanta Singh, that is page 8. P2.
Page 9.
Page
9.
Death certificate, Lordship.
Yes. Page 9, I believe. 9 to the application.
Yes. Annexure P2.
Yes. So let this application be allowed. Yes, record an order. Learned advocates for the parties are present. The application can 3 of 2025, which is filed for recording the death of respondent number 4, Ajanta Singh, and substituting her legal heirs, is taken up for consideration. Her learned advocates peruse the petition filed. Upon perusing the petition and hearing this learned advocate, this application for substitution stands allowed. Let the name of respondent number 4, Ajanta Singh, be deleted from the cause title, and the name of her daughter, Nomita Singh, be substituted in her place and stead. The department to carry out the amendment within a period of 2 weeks.
Lordship. And Lordship, the paper book that I have prepared, filed and served. So Lordship, can you fix the matter any date as Lordship? This is the
Let this
appeal
matter
of Mr.
appear
King.
for hearing on 27/11/2025.
Lordship, 27/11, by that time, his Lordship directed the department to carry forth the order. So some time is required. So file will be sent down.
Let this matter appear for hearing on 3/12/2025.
Lordship. So in the meantime, the officer directed to send down the file.
Yes, the files be sent to the department for carrying out the amendments.
Lordship, I'm
Grateful to you.
ঠিক আছে অমিত রঞ্জন রায়
Lordship, this is insurance company's appeal, Lordship. Lordship, I have already deposited the statutory deposit of 25,000, Lordship. Lordship, can 1 is for the stay petition and can 2 is for delay petition. There is a delay of 115 days.
Have you served the other side?
No, Lordship, not served. This is the first time this matter has came up.
So
Lordship.
unless you see,
And within time, only the certified copy, I have obtained the certified copy a
question is,
bit
you
late.
see, unless you serve this CAN application upon the other side and this section 5 is allowed, I cannot pass any order of stay.
Yes, Lordship, kindly gives direction. I have served upon the opposite parties.
Yes. Learned advocate for the appellant is present. Let the application CAN 2 of 2025 and CAN 1 of 2025 be served upon the respondents. Such service be made within a period of
1 week I will do.
1 week.
This is in Nudia.
And let this matter appear on 24/11/2025. In the meantime, you take steps before the trial court. Otherwise, if
Yes,
it is
that
executed,
is
it will be meaningless.
Yes, Lordship. That
Unless this condonation application is allowed, court cannot stay further proceedings. And if in the meantime, if it is executed, it will be meaningless. So at least you intimate the trial court that the matter that an appeal is filed.
That's why I'm asking for a short period of. Lordship, may the receipt copy may be kept with the record.
That you keep it with you. On the next day, I shall pass that order.
My lord, the 32 is insurance appeal. Pursuant to the earlier direction passed by this honorable court, my lord, I have secured the entire compensation amount before my lord's
I am appearing for the respondent. My lord, I paid leave to file the paper book and copy be served upon my lord defense.
Lord, today, your lordship will kindly make this stay absolute and dispose of this stay application and not fix up the date for hearing, my lord. May I, for my lord's consideration, my lord, I just hand over the deposit slip.
Yes, record an order. Learned advocates for the parties are present. As the appellant insurance company has deposited the awarded sum in terms of order dated 21/5/2025, the judgment and award passed by learned additional district judge, 3rd court, Paschim Medinipur, on 16th day of January 2025, in MSC case number 567 of 2020, shall remain stayed till disposal of the appeal. Stop. Let the paper books filed today be kept with the record, Let this matter appear for hearing on 3/12/2025.
Obliged to my lord. Your Lordship, this is my appeal, Your Lordship. On previous occasion, the coordinate bench has directed us to secure the entire sum. I have secured the challan copies here, Your Lordship, and the stay to be made absolute, and the affidavit of service is also there, Your Lordship.
My lord, I am appearing for the response.
Yes,
The same
recorder,
prayer,
give
my
the
lord.
recordটা দিন একটু।
I'm finding the paperwork. Paperwork has been served.
Yes, Your Lordship. Receive the paper.
Is the appeal is on quantum or point in
Yes, record an order. Learned advocate for the parties are present. As
কত টাকা চালান?
the appellant insurance company has deposited the awarded sum in terms of order dated 21/5/2025. The judgment and award dated 30th August 2024 passed by learned additional district judge, first track third court, Shodor Poschim Medinipur, in MSC case number 549 of 2020 shall remain stayed till the disposal of the appeal. You have filed the paper books.
And also copy.
Sir, copy, sir.
Let the paper books filed be kept with the record. Let this matter appear for hearing. How soon can you come ready?
Next week.
20th, 24th, Your Lordship. 24th. 24th. No.
25/11.
Lordship, 24th, there's another matter is coming. 24th would be.
Okay, 24/11/2025.
My lord, item number 34, which I understand is the first item under hearing. Now,
So I'll take it up after recess.
Well, that is why I'm just mentioning, my lord. Possibly there will be no hearing because if my lord will recollect kindly, that there was a direction for filing a supplementary paper book since two documents were illegible. Now, what I have understood from my learned friend is that these are still illegible, so I need to look into the TCR and try to find out how legible is
Anyway,
the PP
record
in
an
the
order.
TCR.
Learned advocates for the parties are present. Time to file the supplementary paper book.
My lord, actually this paper has been supplied from the tribunal below. That is certified copy, xerox copy of certified copy. My lord, from TCR it will be. Actually, the fact is that the question which has been raised by the appellant should not be looked into because of the fact that question has never been statement.
Anyway, I shall consider that at the
Yes,
time.
my lord, we'll consider.
The time to file supplementary paper book stands extended by a period of 2 weeks. Let this matter appear on.
My lord,
in the meantime, my lord will kindly direct the appellant to take an inspection because I need to see the original.
The appellant is also permitted to take the take inspection of the documents. Let this matter appear on 26/11/2025.
My lord, the next matter.
Hearing, so I'm coming.
My lord, I'm not ready. My lord. It's my appeal. Mr. Mondol is for the other side. My lord, I have to go through this, my lord, the case in its entirety. Your lordship, I will take it up on Monday, my lord.
Okay, not this week.
Not this week, my lord. I'm grateful to your lordship.
And lordship, next matter 36.
It is to be heard.
No, lordship, there is some application. The application not even reached lordship's court. Oh, and lordship kindly আজকে এসছে application? No. And lordship, the application 2 is not with the file. So I believe it will reach by today.
So I'm making it not today only.
And lordship, another plea is that I have also filed one cross objection. This is 134.
Okay, give the slip, it will appear.
Yes, lordship. No, lordship, kindly pays one order is required. Otherwise, they cannot send the cross objection. Kindly pass the one line order.
Yes,
Guide the
order.
department. আরে কটটা আসবে না তো ডিপার্টমেন্ট থেকে
না, এটা তো লিস্ট হয়ে যাবে তো, ফাইল আসলে তো লিস্ট হয়ে যাবে। ওকে, নট টুডে।
কালকে রাখবি
Monday.
Monday.
I'm making it just not today.
Not today.
Or you want not this week?
Not make it not this week because it will reach.
Okay, Friday these matters will not be taken, not this week.
Not this week. Time better.